Same order.
Lordship, same.
Yes, Your Lordship. Lordship, two
Notice.
batches. Yes. Lordship, two batches of petitions were listed earlier. And in the second batch, Your Lordship had given the date of 22nd of October.
You want it on 22nd?
23rd, I'm sorry. 23rd of October.
All right, heard. Council. Issue notice. Returnable on 23rd October. Steps on respondents by usual post registered post within 7 days from today. List accordingly.
Deeply obliged.
Highly obliged.
In order to asylum.
Wait, please, Your Lordship. My lord, I may be allowed to withdraw the same. My lord, petitioner got
Heard
the
Learned S. Bora, counsel for the petitioner, and MSP Sharma, learned CPC for the respondent. Learned counsel for the petitioner submits that
In-
on instructions that the petitioner does not wish to process. Proceed with the review petition any further. Accordingly, the same stands dismissed on withdrawal. As not pressed.
Yes.
As not pressed.
My lord.
Although this matter has become infructuous because the judgment passed by learned single judge has been interfered and has been set aside by the division bench.
It is submitted by the learned counsel for the review petitioner that the judgment against which the review is sought for, being the judgment and order dated. Which judgment? This page 22.
Yes, my lord. Page 22, my lord.
Judgment and order dated 3/11/2022, passed in WPC 1607 of 2020, has been interfered with by in an intra-court appeal, being writ appeal number 107 of 2023, passed by judgment delivered on 5/8/2024 in an intra-court appeal, being writ appeal number 107 of 2023. Such submission is not disputed by the learned counsel for the respondent. Accordingly, the review petition stands dismissed and not pressed. Yes.
That I have filed an IA for early admission hearing.
Let us hear the matter. Why and I will begin the hearing if you want.
Yes. Here, my lord, the issue is involved.
My lord, before that, my lord, starting hearing, my lord, may I submit, my lord? My lord, this IA was is preferred, my lord, basically on the basis of his husband passed by this honorable court, where, my lord, the appointment of my lord own arbitrator by railway has been, my lord, rejected, and my lord, it was direct, my lord, one arbitrator was engaged, my lord. My lord, lordship may kindly come to page annexer 1, page 12, my lord.
Oh,
There are, my lord, of the IA, my lord. My lord, there are two judgments, my lord, in the same issue, my lord, on the same issue, my lord. One was passed, my lord, in this, my lord, arbitration precision, where, my lord, this is, my lord, the relevant portion, my lord, lordship may kindly come to page 15. Page 15, my lord, relevant portion. May I read, my lord? While considering the above rival contention, it has been brought to the notice of this court that only
page number?
Page number 15, my lord.
15.
Yes, my lord.
15. You are referring to which I?
My lord, IA, my lord.
I number?
IA number, my lord. What number I do? Huh? Item number 6, my lord. IA number, my lord. I'll tell you, my lord. I have not written that item number.
2830.
My lord.
But 2830 para 15, which paragraph you reading?
Para 15, my lord,
Sorry,
page
page
15, my lord.
Page 15, which paragraph?
Page 15, my lord. My lord, one para, my lord. Page number, internal page number 4, page 15, my lord. Otherwise, page 15, my lord.
That is page 16 in this copy.
Yes, my lord.
Yeah.
My lord, yes.
Please read.
While considering the above rival contentions, it has been brought to the notice of this court that only in Union of India versus Tantia Construction Limited, special leave petition, so and so decided on 11/1/2021, but also in the recent decision of the Honorable Supreme Court in JSW Steel Limited versus Southwestern Railway and another, the matter have been referred to a larger bench to decide the legality of the decision rendered by the Honorable Supreme Court in Central Organization for Railway Electrification, SUPRA. In view of the matter, this court is of the opinion that it will be more appropriate to wait the decision of the larger bench of the Supreme Court as regards the efficacy of the decision of the Honorable Supreme Court in the Central
I
Organization.
have really not been able to read the paragraph which you are referring.
My lord, it's continuing page probably, my lord. That is why, my lord, I'll have to give the content. Now, my lord, the numbering is, my lord, different, my lord. So, my lord, it will,
Does the page you are reading from, does it contain any paragraph?
yes, my lord, actually, my lord, it is Annexure 1. Lordship may kindly come to Annexure 1, my lord, of the IA, my lord. Annexure 1.
Yes, Annexure 1,
Annexure 1, my lord.
internal page
Internet page 12, my lord.
of 4. All right,
My lord, arbitration petition 18 of 19, my lord.
all right.
Yes, my lord. My lord, Lordship may now kindly come to internal page 15, my lord.
15.
51.5, my lord. It starts from 12. My lord, I am reading, my lord.
Yes.
15, my lord. My lord, while considering the above rival contention, my lord. Top,
Yes, okay.
my lord, I am reading
Yes,
once
yes,
again.
please.
While considering the above rival contentions, it has been brought to the notice of this court that only in Union of India versus MS Tantia Construction, SLP number so-and-so dated so-and-so, but also in recent decision of the Honorable Supreme Court in JSW Steel Limited versus Southwestern Railway, SLP number so-and-so dated decided on 16/8/2022, the matter have been referred to a larger bench to decide the legality of the decision rendered by the Honorable Supreme Court in Central Organization for Railway Electrification, SUPRA. In view of the matter, this court is of the opinion that it will be more appropriate to await the decision of the larger bench of the Supreme Court as regard the efficacy of the decision of the Honorable Supreme Court in Central Organization for Railway Electrification. Malab, in this Malab judgment, Malab, Central Organization for Railway Electrification, Malab, it was hold that Malab Railway can engage its own arbitrator, Malab. Malab, that judgment was referred to a larger bench, Malab, which is Malab pending before the Honorable Supreme Court. And most probably one day, Malab, if I am not subject to correction, Malab, one hearing also, Malab, might have taken place, Malab. So, Malab, now, Malab, whatever the next judgment of our High Court has come, my lord. Lordship may kindly see the next page, my lord, Annexure 2.
Yes.
My lord, Lordship may kindly come to internal base 23, my lord, the relevant portion. Internal page 23, my lord.
There is no
There-
internal page 23. Internal page means the page of the judgment,
Yes, my lord,
not continuous paging.
not comment.
Paragraph 4.
My lord, paragraph 25, my lord. Lordship may kindly come to paragraph 25, my lord. Paragraph 225, my
Yes.
lord. In view of the reasons stated above, the arbitral tribunal constituted by the railways in terms of the letter dated 30/10/2023.
Why don't you read the entire judgment?
My lord, I'll read, my lord. I'll read, my lord. My lord. My lord, may I read, my lord?
Ah,
Mr. R. My lord. Heard Mr. S.J. Sharma, learned counsel for the petitioner, and Mr. A. Gayan, learned CGC. The present petition is for appointment of arbitrator under section 11(6) of the Arbitration and Conciliation Act 1996. The petitioner's case is that the petitioner entered into a contract agreement with the respondents to build and operate a 25,000 metric ton capacity godown with private siding under the Private Entrepreneurship Godown Scheme of FCI. Consequently, contract agreement dated 2/7/2018 was executed between the parties. Dispute having arisen between the parties, the petitioner has filed this application for appointment of an arbitrator. As clause 64 of the contract agreement provides for resolution of dispute between the parties by way of arbitration by constituting an arbitral tribunal made up of members to be appointed by the General Manager, Northeast Frontier Railway. The petitioner's counsel submit that though clause 64 3 subclause A subclause Roman 2 of the contract agreement provides that the dispute between the parties is to be referred to a third member arbitral tribunal to be constituted by General Manager NF Railway. The arbitrator would have to be appointed by this court and not by the General Manager NF Railway. He submitted that this due to that is due to the fact that General Manager NF Railway cannot be appointed as an arbitrator. He has an interest in the dispute and not in a neutral person. As such, the General Manager NF Railway cannot in turn appoint any other arbitrator. The petitioner counsel submits that due to the dispute between the parties, the respondent railway wrote a letter to the petitioner stating that an arbitral tribunal was constituted in terms of clause 64(3)(a) Roman 2, which states as follows. In cases not covered by clause 64(3)(a) Roman 1, the arbitral tribunal shall consist of panel of 3 gazetted railway officers not below JA grade or 2 railway gazetted officers not below JA grade and a retired railway officer retired not below the rank of SAG officer. As arbitrator for this purpose, the railway will send a panel of more than 3 names of gazetted railway officers of 1 or more departments of railway, which may also include the names of retired railway officer empaneled to work as railway arbitrator to the contract within 60 days from the day when a written and valid demand for arbitration is received by GM. The contractor will be asked to suggest the General Manager at least 2 names out of the panel of appointment as contractor's nominee within 30 days from the date of dispatch of the railways of the request by railway. The General Manager shall appoint at least 1 out of them as the contractor's nominee and will also simultaneously appoint the balance number of arbitrators, either from the panel or from outside the panel, duly indicating the presiding arbitrator from the amongst the 3 arbitrators so appointed. GM shall complete this exercise of appointing the arbitral tribunal within 30 days from the receipt of the names of contractors nominee. While nominating the arbitrators, it will be necessary to ensure that one of them is from accounts department and an officer of the selection grade of the accounts department shall be considered of equal status to the officers in SA grade of other department of railway for the purpose of appointment of arbitrator. The petitioner's counsel submitted that the petitioner had been requested to waive his right under section 12(5) of the Act so as to enable the respondent to appoint 3 serving retired railway officers to constitute the arbitral tribunal. The petitioner refused to waive his right under section 12(5) of the Act and instead filed the present writ petition for appointment of independent arbitrator. The petitioner's counsel submit that the subsequent to the filing of this writ petition, the respondent constituted an arbitral tribunal consisting of 3 serving and retired railway officers to decide the dispute between the parties filed later dated 30/10/2023. This court, on hearing the parties filed order dated 10/4/2024, have held that as the petitioner had a right not to concede to waiver of section 12 subsection 5 of the Act, keeping in view of the requirement of section 12(5) and 7th schedule of the Act, proposed an arbitral tribunal to consist of Honorable Mr. Justice C.R. Sharma, retired, as chairman of arbitral tribunal, with Mr. Minal Kumar Bhattacharjee and Sri Pradeep Kumar Das, who were both retired as district and session judge. Further, the registry was also directed to communicate with the proposed member of the arbitral tribunal seeking disclosure as provided under subsection 8 of section 11 of the Act. Consequent to the order dated 10/4/2024, reports have been received to the effect that the proposed arbitrator were willing to take up the dispute between the parties. Mr. A. Gayan, learned CGC submitted the arbitration clause provided in the contract agreement between the parties provide for an arbitral tribunal made up of retired oblique serving railway officers, and petitioner was to suggest 2 names from among the list of 4 names that had been
Okay.
sent to him.
This appears to be the correct view.
My lord. But thing is this, my lord, the previous judgment, my lord, by this honorable court, my lord, where my lord, we have cited one, my lord, judgment of the honorable Supreme Court, that is, my lord, Central Organization for the Railway Electrification, my lord, where the honorable Supreme Court has ruled that railway can appoint its own arbitrator, my lord. That is the, my lord, my lord, law holding the field till today, my lord.
No,
My lord, I am submitting, my lord, that is my
the
lord.
law holding the field is Parkin.
My lord,
So whether it is to be followed or not followed, this has been,
my lord.
what has happened to this order? Has it,
My lord, now things, my lord, the other order, my lord, which is passed, my lord, that was challenged before the honorable Supreme Court, my lord, and my lord, this is my lord. My lord, I have taken, my lord, it to print out, my lord, from the website, my lord.
no, is there any stay or anything like that?
My lord, it has probably not been listed, my lord. My lord, it is filed, my lord, one day, my lord, it has been, my lord, listed, my lord.
This full bench matter, I think it has been reserved.
In the Supreme Court.
Huh?
Actually, my lord, as per my information, my lord, the central government asked some time to consider this matter by the this law commission. So that is why the case was urgent. And here also, that case has been considered by this honorable court, central organization case.
My lord, my humble submission is, my lord, since
You
my,
give us a correct status of what has happened to the full bench judgment, I mean the larger bench judgment
I will inquire.
of
my
the
lord.
FX court.
Yes.
Subject to correction, I
Yes.
read in the news somewhere that the judgment has been reserved.
No judgment. In this case also it has been considered, my lord. This honorable court has considered the central organization case.
Yes, but if the judgment has been reserved, or if there is a possibility of the
I-
judgment being available, then let us.
As per my information, my lord, the government is going to consider to amend some provision in the light of the said judgment. So, let us status. I will inquire, my lord.
All right, then. We'll have it after vacations.
Yes, afterwards.
Third learned counsel for the parties. Both the councils at the bar have submitted that the central
Organization for Railway Electrification.
organization for
Railway Electrification.
railway electrification judgment rendered by the apex court quoted in 2020-14 HCC 712 has been referred to the larger bench for reconsideration in view of the contrary view adopted in the said judgment. In view of 2 earlier judgments of the apex court, namely Perkins Eastman, Architects so and TRF Limited. Learned counsels of the bar submit that the status of the matter is not known. They would like to apprise this court immediately after the reopening. Accordingly, matter stands referred to be listed again on when can you give us?
Last week of October.
28th.
Twen-
28th of
Yep.
2020.
Both the cases, my lord.
Both the cases.
Much obliged.
In
Yes.
this case, argument was concluded. My learned senior has already filed the written argument.
Okay.
I am submitting today.
You are submitting what?
Written synopsis.
Written synopsis.
Otherwise, hearing is complete.
All right. Then we will keep it.
Chair.
not CAV, we'll keep it on 28th itself.
My lord, I'll be out of station on 28th.
Date of,
Then November,
no,
November,
28th October.
28th
Or-
October.
October, yes.
Learned counsel for the parties have permitted to submit their written argument. The union, the income tax department submits that it will file its argument during the course of the week. When are you filing it?
Today itself.
During the course of the day, with copies served on the council for the petition. Accordingly, let the matters be listed again on 28th of October.
All right.
The affidavit is on
Not
the way,
filed.
my lord. No, if it is on the way,
No,
I'm
no,
filing
no,
it.
not filed.
No, no, it is on the way. I will file it by
Lordship.
my lord, 3 or say before 4 o'clock, I will file
Last
it.
date
How will
also
it
we
come
said the
on the-
same thing.
My lord, there, somebody's, my lord, courier is coming, my lord, with the affidavit, signed affidavit from the joint secretary, joint commissioner.
Okay. Otherwise,
Just now, my
it is
lord,
forwarded,
I-
Lordship. By MIRC, Lordship.
By 4, I will
by
file it.
MIRC.
At least I will serve a copy to them. There is no annexes, my lord.
No, no, we want to know when are you filing it?
But today, sir, lordship may record it, my lord.
Today.
Yes, yes.
All right. Mr. B. Gogoi, Learned Standing Council, Taxation, submits that the affidavit is required to be filed on behalf of the state will be filed during the course of the day with prior copy served on the
Yes, sir.
council for the petition. Stop. MSN Haveli Learned Council for the petitioner on the other end submit that this matter is qualified by judgment and order dated
Okay. MIRC.
3508.
Lordship, 4708 of Lordship's judgment. 470, 9798 of 2022.
4798
98 of 2022.
of 2022.
Dated 12/6/2022.
Dated 12/6/2020.
Yes, sir.
Accordingly, however, considering the fact that
Next
the
week,
earlier director responded to file a affidavit and on the assurance given by the council, let the matter be listed again.
Tuesday. Coming 22. 24 being a evening. 24.
Tuesday. Tuesday or Thursday, my lord.
We'll have it on 27.
27th also.
27.
Oblige.
Much
On 27.
May I please, also, it's a petition under section 11(6) of the Arbitration Petition Act, my lord. My lord, on the last occasion, they have taken time for filing objection.
Have you filed?
No, not filed, my lord.
Yes, my lord. The affidavit, or everything has been prepared, but the sign for the respondent is in Bangalore, my lord. We have sent the affidavit. We need time to just file it, my lord.
How much time do you require?
Lordship, after the vacation or 3 weeks time.
Where is the arbitration clause?
My lord, page 26, para 25, my lord. Page number, my lord, 26, in para 25, it is, my lord, India agreement arbitration clause is there.
What is the dispute?
My lord, dispute regarding, my lord, some So we have stolen office space to the respondent, my lord. In the meanwhile, my lord, they have given for the rent, the maintenance and the other charges we are paying as a builder, my lord, for the, but they have failed to pay the maintenance charges and other expenses. It is from, my lord, since 6 to 7 years, my lord. Continuous reminder we have sent, my lord.
Where have you noted all that?
My lord, page 44 is the notice, my lord.
No, no. Where is that agreement where it says that they'll have to pay for all that?
My lord, in the agreement, my lord, first, my lord,
This is a
21, my lord.
This is a deed of sale.
Yes, my lord, for office space, my lord. My lord, clause 21, my lord, page number 26. That the purchaser shall pay the maintenance charges proportionate to the area of his space for the use of common service and amenities to the vendor or any person or agency appointed by the vendor for the said purpose, my lord. And my lord, we have annexed the, my lord, particulars, my lord, we have calculated the amount, my lord, at page 38, my lord, which includes, my lord, outstanding electricity
So
charges.
this is to be paid to whom? Maintenance charge to be paid to whom?
Because, my lord, since they are not paying, my lord, the maintenance charges and others, on behalf, we are paying, my lord, on behalf of them, my lord.
Why?
Because, my lord, paying the, my lord.
You are being given the entitlement to discontinue common services and amenities. Same para.
Yes, my lord, we have sent the notices and even, my lord, for this.
They are required to pay the maintenance charge.
Yes.
They have not paid.
Well-
You are entitled to stop these services. Why are you making the payment?
My lord, they, meanwhile, my lord, they have paid, up to the total amount, some of the amount they have paid, my lord. They have ensured that the remaining amount will be paid, my lord, later on, my lord, subsequently. That's why we have not disconnected, my lord, directly.
What about you? What is your objection?
The petitioner is saying there's a lot to say in this affidavit, my lord. Just allow us to just file the
No, we
affidavit.
are asking you what objection, primary objections have you got? Do you disown this agreement?
Yes, yes.
You disown.
Uh,
You say this is not your signature.
I don't have the full brief, exact brief. That's what I'm
My lord,
asking.
in the reply, my lord, they have said, my lord, whatever amount we have, my lord,
We
claimed,
are
my lord.
fixing it on 27th. You get your instructions or we dismiss. We allow this petition. 27. Whatever affidavit you want to file, file.
Okay.
List on 27th of September, by which date the respondents will file their necessary objections or affidavit as leave granted by the court in the earlier orders. Mr.
S. Hazarika.
S. Hazarika appears for the petitioner.
W. Ahmed. W. Ahmed.
W. Ahmed appears for the respondent.
I'm deeply aware.
This is a matter relates to railway contract, my lord. Dispute arose between the parties because of the termination of the contract, my lord. And interim protection was given by the under section 9. Now we are for appointment of arbitrator. my lord.
Lordship, we are filing our affidavit today, Lordship. So it may be taken up next week, any day.
No, what is your ground for objection?
Lordship, may be taken up the Wednesday, Lordship, which affidavit will.
Pending since month of March, my lord.
Yes, Lord.
4 to 5 adjournments have been.
So see, once you agree for an arbitration, go for it, sort out your dispute. Unless you say that the clause is not applicable for one reason or the other.
In fact, my lord, the arbitration clause they have admitted. They wanted a disclosure from us that we are not going to press on section 12(5) of the arbitration
right.
agreement. That
Yeah.
cannot be, my lord.
You
I have
can't
annexed
force
that letter, my lord. So arbitration agreement is already admitted, my
You
lord.
cannot force them. It is a voluntary waiver. If they on their own say that we don't want it, they don't want it.
But since there is a conflicting decision of the Honorable Supreme Court Lordship on this issue, whether they can waive it or not, Lordship.
Supreme Court has not
Yes.
Do you have
decided.
the judgment of the Central
Yes, Lordship.
Railway Organization?
Lordship.
Let us- Which paragraph? Hey, you file it first.
Lordship,
Let us see.
next week I need it, Lordship. Today we are filing.
Wednesday.
Lordship.
List on Wednesday. On which date? The 25th. On which date the learned counsel for the respondent will file the objections as free.
My lord,
Mr. G.
can it-
Rahul appears for the
Wednesday will be 25th, my lord. 20, can it be on 27?
all right, 27. 27.
Lordship, in this case, we were supposed to file affidavit, Lordship. In this case also, we could not file it by next week, Lordship, if possible. It
Your
may.
Lordship, 3 adjournment has already
Lordship.
been given on the
Lordship.
same basis. So I think it is a high time to appoint an arbitrator. In the last 3 orders, the same thing has been
Lordship.
told by the
Persons, Lordship, on with Friday, it may be fixed. As an staff approximate.
Lordship, it cannot go long.
Where is the agreement clause?
That has been submitted here in previous contract, total contract agreement was submitted.
I know which clause.
70, condition 70 of the contract.
70.
70, yes. That is 16 and 17 page number. 15, 16, 17 condition.
In the additional affidavit.
Yeah, the contract agreement has been, whole contract agreement was submitted. And the George copy is enclosed in petition page number 15, 16 and 17.
So which clause in the contract refers to arbitration?
Condition 70, your lordship. Xerox copy is enclosed in petition page number 15. Since here it was flagged, sir, Lordship. Page was flagged, but I don't know if now the flag is there or not.
You find out for us, tell us.
Page 65, conditions.
No, this is an amendment.
Your Lordship, it is only just given and ended in this. Otherwise, the whole elaboration was given in contract agreement and in petition, original petition, page 16 and 17, elaboration is given.
16 and 17, you have given an extract of this.
No, Your Lordship, it is contract agreement. This is an independent, I mean, there is a rule, general condition of contract, where elaboration of 70 is given.
Where? That is what we want to find out. Where is that?
That is, Your Lordship, it is general condition of contract.
Where is that general condition? Not here.
No, not here.
Why?
Because it is, we sign it is there, and this is in page number condition 70 is only referred, and in not elaborated. In page 65, you will see it is only.
Yes, madam, what is it? Where is the contract? They are not given a copy of the contract.
No, Lordship.
Why? Why are they not given a copy of the contract?
Lordship, I will annex it in my affidavit, Lordship. if
So
I-
you annex it is okay, but if there is a signatory to the contract, they must be, they are entitled to a copy of the contract.
In first hearing, you said me to give the Xerox copy of this contract agreement. That's why I gave it to
In this,
the court.
in this year, I have no instruction, Lordship, whether he has given any agreement of the contract.
You get the agreement on Wednesday or we are appointing it because
Lordship.
your
Lordship,
objections.
Lordship.
Also, there cannot be any objection. They didn't appoint any arbitrator within 30 days, and after that, we move the High Court.
We'll fix it, we'll pass orders on Wednesday,
Lordship.
27th. Third learned council to the party, learned council to the learned CGC for the response, something that she would like to file her response. So, although opportunities were granted, the same is not yet been filed. However, as a matter of last opportunity, respondents are permitted to file their objection if any, and to be listed again on 27th. It is made clear that if any objections as prayed for are not filed, the court would proceed to pass necessary orders on the basis of the pleadings available on the court. Yes. And
Lordship, in this case, I could not contact the respondent, Lordship, therefore some more time may be given in this case. After vacation, it may be taken, Lordship.
Your Lordship, in this case, there is only one dispute that the compensation was recovered from me for delayed completion of work, and against which I wrote the department for waiver law to refund my compensation, which was not entertained by them. So only just one dispute is there.
I have
And
to
they
take
even-
action, Lordship, in this regard. So after vacation, Lordship, this matter may be taken up.
Your Lordship, they even never bothered to reply my letter
You-
for appointment of
the last
arbitrator.
order recorded was
Yes,
that you
yes,
file
Lordship.
it positively by 1 week.
Lordship.
Then?
So I inquired from the Lordship army authorities, they also could not give me the address, Lordship, proper address. Which authority I have to,
You had given an undertaking to the court that you will file it positively within 1 week.
yes, Lordship, I have contacted with the,
Then don't file. Which authority you are, whose address is it
This is-
required?
this is Lordship, Shillong, Lordship.
It's given in the post title.
Lordship. Commander Works Engineer Shillong June. I have contacted with the Guwahati Division, Lordship. They are not, they have said that it is relating to the Shillong zone.
Your Lordship, in this, the appointing authority,
He has
chief
also
engineer
given me
Shillong.
one
See,
number,
the
Lordship.
problem is you don't enclose the original contract.
Yes,
We don't
Lordship.
even know what is the ground on which the, where is the dispute,
No details.
where is the
given,
reference
Lordship.
for the arbitration clause.
Condition 37 is enclosed.
Your statement will not do.
Your Lordship, my point is that once we complete the work before paying and before submitting final bill, we have to deposit the contract agreement with the department.
We don't know that, but you must find a way to get a copy before the court.
Your Lordship, in another you will see that
You are giving an extract.
yes.
But then where did you get the extract?
This is part of the contract agreement.
Then you get a certified copy.
So we have deposited, we don't have it. That is the problem, Your Lordship.
So what can be done now?
So there's never disputed.
Every matter we can accommodate you like this, that you will not place the contract before us. How do we pass orders here?
Your Lordship, my point is that I wrote the chief engineer to appoint the arbitrator. Had there been any dispute, they have replied it, but they never replied it.
You have come before the court seeking an order on the 11.6. For the court to pass an order, we must satisfy that there is a condition for contract. You are giving a extract of that clause.
My Lordship, I will request the council to go for G Guwahati. It is just 15 kilometers from here, and they can get the contract agreement there.
You are the one before the court.
No, Your Lordship.
They are the
I
party
will
to
not
the
get,
contract.
but agent council, they can get the contract agreement. They will not give it to me. Otherwise, I would have gone tomorrow or from this court straight to the G Guwahati Satgaon area. But they will not give it to me. As a council, they will give to the lady. No council, sir. They will not
Yes.
entertain me now.
Lordship, some more time.
We want to see the contract, or we are issuing notice on your respondents to get whatever documents and the commander works engineer.
Lordship.
Are you going to get it, or we direct presence of the commander works
No,
engineer?
Lordship,
Your Lordship, it is available in G
Lordship,
Guwahati
on
itself.
27, it may be taken up. Lordship. I'll try to get it.
Your Lordship, my submission is that this contract agreement is available with G Guwahati, Satgaon, Milk Cantonment area.
How?
I know this is the executing authority. That is, the work is
Your contract is with Shillong.
that is accepting officer, but the work executed by garrison engineer Guwahati and paying authority is G Guwahati also. CW is that is like a superintending engineer who accepts the tender for more than value or for particular work. But the executing authority is garrison engineer Guwahati. And all the relevant document will be available in G Guwahati. So, Your Lordship, notice can also be sent to G Guwahati. That is responded.
Please read para 3 of the petition.
Okay.
Para 3. It appears to be a work to be executed in Guwahati. Who is the signing authority?
Your Lordship? In original petition, page number 9, where work order is given, name of work is given, and we are under G Guwahati. The work will be executed under G Guwahati. PW Shillong is superintending engineering, superintending engineer, the next higher authority, accepted by. In the same page, your lordship, the work order is signed by Dharmender Singh, Lieutenant Colonel, Garrison Engineer, Jiguat.
Madam, you are not able to explain anything. We'll have to call your garrison engineer.
Lordship, on 27, it may be fixed, Lordship. I will try to get it, Lordship.
No, we are fixing it on 25th.
Okay.
You get it.
Okay.
Whatever instructions you want, you get it. Don't waste the judicial time of the court like this. If you are not instructed, why are you appearing in court?
Okay.
Why are you appearing in court? Let the matter be listed on 25th, enabling the learned CGC to obtain the required instructions in the matter.
Problem.
It is made clear that the relevant contract document, which was entered by and between the petitioner and the respondents, should also be placed before the court by the respondent. Mr. Sanjay Sharma, petitioner in person, appears. Sanjay Sharma appears as a petitioner in person. The matter. List on 25th of September.
Problem.
This matter relates to termination of distributorship by the Vodafone, my lord. Originally, a suit was filed, my lord, and in that suit, they themselves have filed an application for referring the matter to arbitration.
What happened?
Madam, I am supposed to file one objection, but what happened subsequent to the withdrawal of the civil suit, there was some settlement took place between the parties. I am waiting for instruction on that. Some payments has been made to the petitioner.
Can be decided by the arbitrator.
The dispute may not survive, my lord. Let me get the instruction, my lord. I'll file the objection, my lord.
You go and place it before the arbitrator. If it is settled in the meantime, it will be closed.
Already payment has been made, my lord, some payment. That is my instruction, my lord.
Pursuant to that, we have issued the section 21 notice, my lord, demanding compensation. Other claims are also there. Arbitration, one amount of unpaid bill may be settled, but there are other payments which are also due. This will be dealt with by the arbitrator. And as per my instruction, my lord, full and final settlement.
Where have you laid out your dispute?
My lord, if your lordship peruses our section 21 notice, page 40, my lord. Page 40 is the section 21 notice, my lord. Notice under section 21 of the Arbitration and Conciliation Act. And my lord, the disputes, the claims, lordship will find it page 45, my lord. And my learned friends, my lord, there's now statement that some amount was paid. Even then, my lord, if your lordship peruses the claim number 2 in page 45, an outstanding amount is still there, my lord, as per our computation.
They've already suggested the name of a.
In fact, lots of my problem is that even I don't have the annexures of the petition also. I'm handicapped by that. They have not enclosed the annexures.
No, well, this is incorrect.
Why did you accept
how
a
are they
copy?
filing a petition?
Why did you accept a?
No, it was sent by post only. Let the instructions come, my lord, immediately after vacation, my lord. In the meantime, we will file your reply, my lord, objection.
There is some dispute.
Yes, there was. Yes.
There was.
Yes.
According to you, these instructions are not available to you, whether these disputes
No, my instruction,
survive today or not.
they have already made the full and final settlement against a said dispute, my lord. Payment has been made, my lord.
Then you get
That-
these instructions by next week. Why send the matter after vacation?
I'll try, my lord.
Let us have it on 25th.
27, my lord.
Let it be in the first week of October, my lord, before vacation.
Only to get the instructions whether the full and final settlement is.
In fact, Lord, we have applied for the certificate copy of the civil suit also. Even that was not
that
with
has
them.
been withdrawn.
That is withdrawn, my lord.
Then,
We have withdrawn with liberty, my lord.
then
It was their application that the matter be referred to arbitration.
Let it come on third, my
Section
lord.
8 application was
3rd
filed
of
by them,
October.
my lord.
no, we want to know if there is settlements are there or is there any dispute. That is all. We are not
Yes,
supposed
Lord.
to decide on the dispute.
Yes, my lord. Let it come on third, my lord. Because we are getting the certificate copy next week, my lord.
Certified copy of a civil suit withdrawn,
For to know about the
filed,
claims, their
filed by
claims, my
whom?
lord.
Who filed the civil suit?
Well,
They
we
filed
filed.
it.
Then they withdrew it. What are you going to read in the certified copy of a suit which they have withdrawn?
Even their payment will not be reflected in the copy of the plaint, my lord.
I want to see the what is
Payment
their
was
initial
made-
claim and
payment
what
was
is
made
been
at
made
the later
with.
stage, my lord.
Whatever their initial claim was, they have withdrawn it.
Yes, my lord.
Then how do you stand by that?
Okay, my lord, from next week, my lord. On 27th.
If there is any difficulty, next week we'll accommodate you. That's a
Yes,
different
sir.
issue. But first, try to find out whether the amount is paid or not. If it is paid, why uh, uh, board are issuing orders under 11.6? 27
Yes,
27.
is agreed to by learned counsel for parties list on 27. Mr. R. S. Puragohai,
Our second, my lord.
R. Sekar, submits that he would like to complete his instructions. The matter. List again on 27. Mr. G. Rahul for the meeting. Yes.
I'm a block.
Yes.
Your Lordship, I just want to refer 4 or 5 paragraphs of the judgment, whatever referred by my learned senior friend on the last occasion. That was basically for the stamp duty. Before that, Your Lordship asked for NCLT orders.
See, NCLT matters were filed pursuant after the application for arbitration, wasn't
Right.
it?
Right.
Which is the ground on which the matter was reviewed,
Right.
right?
Right.
So there appears to be some dispute. Whether
Right.
this dispute is arbitrable, not arbitrable, is a part, is covered by the clauses of the contract or not,
Right.
goes into the aspect of the jurisdiction of the arbitrator.
Right.
So it is for the arbitrator to decide on the jurisdiction.
Your Lordship,
That's
before,
all.
before that, the judgment feels that preliminary observation need to be made before appointment of arbitrator. I just want to refer 4 or 5 paragraphs of this judgment. I am having the court copy, Your Lordship.
Which judgment?
That Civil Appeal 1599 of 2020. That is recent judgment,
That stamp duty.
stamp duty judgment, wherein it clearly says that special law prevails over general law. And if we consider the doctrine of harmonious construction as well, where there is a special law, special court, the matter should be referred over there rather than going into arbitration. I just refer para 125. Para 125, Your Lordship. The last 8 line from the bottom, that this court held that for a court to have jurisdiction to decide a matter, particular matter, it must not only have jurisdiction to try the suit brought, but must also have the authority to pass the order.
You're reading from which paragraph?
Paragraph 125, Your Lordship, court order. 125, last 8 line of the judgment. The arbitrator need to have power to pass any order, whatever we or they are praying for.
That's for the arbitrator to decide.
Right.
The arbitrator, you will have all the opportunity to raise this objection and say whether the arbitrator is
Your
capable of
Lordship,
deciding the issue
Your
or
Lordship,
not.
prima facie findings should have to be there before that.
You are
And
reading paragraph 124,
125.
125. You see?
It must not only have jurisdiction to try the suit brought, but must also have the authority to pass the order sought. In NTPC versus Siemens, the court observed that any refusal to go into the merit of a claim may be in the
No, there's the paragraphs are not telling.
1.5 is something the doctrine of competence.
I'm having the court order, Your Lordship. Download it from the Supreme Court website. I'm just passing this. I have noted down the relevant paragraph. It is only I have noted only 5 paragraphs. I would just want to rely on 5 paragraphs. That is it has been marked. The para 167 and 168 is very important. Apart from that, para 125, 160, 169 and 191. That is with reference to special law. That is with reference to harmonious construction. 125, 160, 167, 168 is very important, Your Lordship, and 198, 169 and 191.
Yes, you take it. We have it.
Yes, sir. 167, 168 is very important, Your Lordship. Then 169, 191.
No, you read 125 according to you.
First of all, with reference to power of the arbitrator to pass the order, whatever that I have already apprised, that it has the jurisdiction or not against the Ministry of Corporate Affairs, whatever we are praying for. Then serious investigation department, the forensic auditor, then against the bank or against any other statutory authority. Then I'll refer.
No, you tell us that under 11.6, in view of the law laid down by this court and Nitya Grolia and all the other, whether to what extent the court to examine under 11. Is the court required to decide the arbitrability of the dispute, to see whether the arbitrator, if appointed, would be competent to decide on this dispute, or is it necessary to just satisfy that there is an arbitration agreement between the parties, and in the event of any dispute, the matters are to be referred for arbitration?
Your Lordship, there is I'll refer one paragraph. If there is a contradictory law, if two law, if
have you filed an appeal against the review order?
No.
Then the order of review is passed on the ground that the arbitration petition was filed earlier. Now, if it is your case that since the matter is pending before NCLT and it's an area covered by the company law, there's no question of arbitration.
Your Lordship, one more thing I want to refer from that order itself, that there were 2 observations on the basis of which that order was passed. One still remain. I'll rely that paragraph as well. That is section 8.1, wherein the detail of the judgments are given in that order. That was remained untouched. Only with respect to pendency, the review was allowed. The review was, if your Lordship,
review order is very clear.
Review order is very clear only with reference to pendency, but second issue has already been decided previously. Second issue remained and second issue remained untouched.
What is the second issue?
Second issue with respect to judicial authority. That is Booz Allen, and several other judgments are also there.
But in view of this law, in view of the recent law,
Your Lordship, this law has never dealt with Booz Allen.
All right, let us turn to Booz Allen.
before that as well, I'll just, as I pray your lordship to refer two paragraphs, 167 and 168 of this judgment. It is a tried law that a general law must not give way to special law. This rule of construction stem for the doctrine generalia specialia but not derogant in LIC versus DG Bahadur, wherein the judgment was the relevant paragraph.
This you are referring in what context?
That special law is already there, Companies Act there, special court is there.
The last occasion, if I remember correctly, I wanted you to point out any provision under the Companies Act which debars proceedings under any
Yes.
other provisions of law, including arbitration.
I'll just
In the
refer.
event there is a matter.
I'll just refer two provisions. One is from Companies Act and one is from Arbitration Act. Companies Act, Section 430. I have an extra book, your lordship.
No, we have sufficient. Yes. Clause
Section 430.
430.
Civil court not to have.
Yes. This is civil court.
Yes.
Yes.
Civil court not to have, no civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the tribunal or appellate tribunal is empowered to determine
Yes.
by or under this act or any other law for the time being in force, and no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this act or any other law for the time being in force by tribunal or appellate tribunal. And what is the matter pending? Matter pending is with reference to ownership of the company, the legitimate directors of the company, the siphoning of funds. These are the issues. And now coming back to the definition of court in Arbitration Act.
Do you have any authority to say that any other law would also include arbitration?
Your lordship, I'll just refer the definition of court in Arbitration Act.
Civil court.
Yes.
Principal civil court.
Yes, your lordship.
Yes.
So this can be termed as civil procedure, and
that interpretation must have a very sound legal proposition. You can't just interpret a particular statute to say that it must mean that only. This is for the purpose of filing an appeal under 34. That the civil court is defined.
But the procedural aspects conducted in the arbitration, your lordship, till now the arbitrator has not been appointed. Wherein the NCLT, the pleadings in main CP is already been concluded.
No, the whole purpose of arbitration is to take matters of dispute out of court and forums.
Then, your lordship, they need to approach the NCLT.
Why?
Under Section 8, subsection 1.
Why? Because NCLT provisions are later, which is evident, which is not disputed by you.
Your lordship, filing just does not mean that it is the appropriate forum. Arbitrator is the appropriate forum.
Therefore, the arbitrator is to decide that it is not the appropriate forum, and the appropriate forum would be the NCLT. Unless you give us, unless you give us a proposition,
then I'll cite certain judgment, your lordship. I'm not carrying today. But one more thing, your lordship, this agreement has already been terminated at my instance.
Why do you need to carry judgments? It's available here.
Your lordship, I have to basically. I have not gone through that judgment because I thought this provisions prevail. Then one more thing, your lordship, this agreement already terminated at my instance. They can very well go for a specific performance. Last year, 16th of March.
You want to go everywhere, but you don't want to go to arbitration. On one hand, you are saying that civil court barred under Companies Act, but then you are asking them to go for specific purposes.
Presuming hypothetically. Presuming hypothetically, Your Lordship.
Yes. We are on this issue of when there is an arbitration agreement between the parties, there is a dispute. To what extent is the court required to intervene or examine while deciding an application on the 11.6? That's all.
Your Lordship,
You are not disputing the existence of the arbitration agreement. Is it your case that this agreement is non-existent or forged or anything like that?
Yes.
It is.
Yes, forgery is there, and forgery application we both have filed.
In so far as the arbitration agreement is concerned.
In furtherance to the arbitration agreement,
Yeah.
criminal cases are pending.
That's
We
a
have
different
prayed for appointment of forensic auditor, then forensic department for the purpose of verification of the signature with reference to appointment of director and transfer of shares. We both have filed, and we both have prayed for as well for the appointment
Where is the arbitration clause?
arbitration clause. One more thing, Your Lordship, the petition they have filed, they have referred to agreement. One is in one of the agreement, no arbitration clause is there, and in the subsequent agreement, there is no reference of the first agreement.
So there are two agreements, 3004 and 2304.
Right.
Right. So what's the agreement?
The arbitrator, Your Lordship, can consider the monetary part, Your Lordship, not with reference to the property, because it is a matter of tea garden. It's in page 67 of the petition, Your Lordship. 11.10.
Yes. Oh, which part of which agreement is this?
That is the subsequent agreement. 30.
That is 23.4.
No.
3004.
Yes, yes, Your Lordship.
Where does one find the date?
Yes, Your Lordship.
Where does one find the date of the agreement?
Date of the agreement, Your Lordship.
That is page 54.
Read it.
Main issue is with respect to ownership of the company, and they have filed. They claim themselves as the owner in this petition. That is the main ground. That who is the owner? I am saying I am the owner. That is pending before NCLT, and they have filed claiming themselves as the owner of the company. Arbitration petition. When the subject matter of ownership is pending, how can they represent themselves as the owner of the company, Lord?
So where is the second agreement?
Second agreement, Your Lordship, they have not, I think they have not attached. I have attached in my reply. That is in my reply 50 and 51.
50 and 51.
Yes, annexure R1 in my reply. They have not attached in the
Page number?
50 and 150 and 151, Your Lordship.
That is in the arbitration petition annexure 1, my lord, page 37, lordship may found.
No, page 150, is it the second?
Same thing, we have annexed it at page 37, my lord.
Of the other petition?
Yes, we have annexed that, my lord, 37.
Yes, it's there, Your Lordship. I'm so sorry. I'm so sorry. I'm so sorry. I have not seen. I'm so sorry. I have not.
In both, there is a separate arbitration clause.
No, the first one is a agreement which is, in fact, my lord, the contract between the parties, my lord, while the making the initial payment. And second is that page 54, my lord, is the share purchase agreement, whereas we purchase the garden, my lord. That is page 54 and page 37, my lord. This was page 37 was signed on 23/4/2021, and page 54 it was signed on 30/4/2021. He is not disputing this agreement, man. Lordship, this is the first agreement, my lord, where uh, uh, clause number 9, my lord, a sum of rupees 50 lakh only paid token advance by check number so and so. So and so. The deal will be completed on or before 15th May 2021. So, so this is merely a contract between the parties, my lord.
It is there in the first.
And what is before the NCLT?
NCLT, your lordship. I am just coming to page number. Allow me 1 minute time. Like, 67. Your lordship. Page 259 of my reply. I'm just referring the prayer what I have made. The facts are that I am the owner since the incorporation of the company. I am the shareholder since the incorporation of the company. I am the director. I am the director as well.
No, what is 259?
259 prayer portion, your lordship,
Of the application.
of the application pending before NCLT.
Okay.
If your lordship refer to
This is a petition for oppression. And
operation, exactly, operation mismanagement, illegal transfer or rectification in register of member of the companies, and further I have filed section 213 as well for investigating into the affairs of the company.
No, but have you prayed for setting aside of the agreement?
Yes.
Where?
Prayer A,
Prayer A?
page 259, prayer A.
Okay.
Your lordship, they have taken 6 crore loan as well from the bank. That has also been, I have requested for forensic audit of the utilization of these funds, claiming themselves to be the owner and director of the company. Then I have prayed against before that a direction be given to the central government for the investigation. Prayer G. Then for the purpose of forgery and fraud, prayer H. This is with reference to ownership of a company. And they are claiming to be the owner and making the company as a petitioner number 1. On what authority, I don't know, your lordship. And the series of forms filed by them before the Ministry of Corporate Affairs, I further prayed that should be taken off from record. That is in prayer W. Further, I want to rely, your lordship, if paragraph number 12 to paragraph number 12 and 13 of the initial order of your lordship, wherein it has been described regarding the judicial authority, the competent court, the 9th February order, wherein no remarks have been made regarding these paragraphs. 6 to 12. Sorry, 9 to 12. Lordship, in the recent judgment, paragraph 169 deals with the court should examine whether its jurisdiction has been out in terms of the procedure prescribed by special law. That is there in paragraph 169 of that recent judgment. (169) para A and para B. Booz-Allen also says, your lordship, with reference to Companies Act winding up matter, NCLT should take care, or the company law board or the High Court having the Company Act jurisdiction, and 241 is an alternative to winding up, your lordship. It is there in the provision.
And what is the stage of the proceedings before NCLT?
NCLT pleadings in the main CP complete. There are several applications filed by both the party. One is for forensic of the documents by both the party. I have prayed for appointment of special officer, and there are 2-3 applications more pending, one filed by them and one filed by me. If your lordship, at the top,
Who has filed the applications before NCLT?
I have filed, your lordship, as they have illegally transferred my shares and directorship. They have changed by forging my signature.
Yes.
Your lordship, para 169 as well, your lordship, of that judgment, it says the principal subject matter as well as the particular perspective or focus illuminates the path to ascertain whether a law is general or specific law, and the court should examine whether its jurisdiction has been out in the terms of the procedure by a special law. Then 191, your lordship.
Is there any interim order of the agreement?
Interim order not been granted, your lordship. Just direction for completion of pleading. Your lordship, the bench has said we'll hear the matter after completion of pleading. In any which ways, your lordship, they have already transferred the shares and
okay, Mr. Roy, there is a prayer for setting aside the agreement
Yes.
in the NCLT.
Lordship, so for the law application that the constitutional judgment, 7 judges judgment, my lord, that is made clear what is
That's all right.
1840, my lord,
But
the
your-
act, and now present the modern law, my lord.
No, that's okay. But your basis for referring the matter to arbitration, the agreement, that itself is questioned.
No, that's what, Lord, let me place the paragraph 131, Lordship, see about the judgment, my lord. Paragraph 131. Then I'll show that how the law has been developed, my lord. Para 131 is the main
131 in this,
in this judgment, my lord.
are you also relying on a court copy?
No, no, I'm relying on the judgment, my lord.
All right, 131.
131, my lord.
Yes.
Section 16 empowers the arbitral tribunal to rule on its own jurisdiction, including ruling on any objection with respect to the existence of or validity of arbitration agreement. Importantly, the parties have a right under section 16.2 and 16.3 to challenge the jurisdiction of the arbitral tribunal on the ground such as a non-existence or invalidity of the arbitration agreement. The arbitral tribunal is obligated to decide on the challenge.
Supposing we refer it to arbitration, how will the tribunal decide on the authenticity of the whatever allegations they are making against you?
Lordship may say the first agreement, first when they file the company petition, my lord, when they have served the copy but they have not filed it. There, my lord, they have a different picture, my lord. Subsequently, they improved their case and they made a different story, my lord.
If you come to page number 259 of
Yes.
arbitration petition 2.
Yes.
There at prayer A is that all agreements on or after 3004-2021.
Yes. Prior to that agreement, they are not disputing it. There is one agreement prior to this.
But it doesn't contain the arbitration agreement, arbitration clause.
Yes, that. No, what I mean to say, my lord, this is okay, my lord. First of all, first they have projected the case, which is, my lord, in fact, that is suppressed, my lord, in a different footing. Subsequently, they improved the case. They made a case of operation mismanagement after 7-8 months. So that is their, my lord, they want to avoid the jurisdiction. That is one part of it, my lord.
No, that is okay, but
Because it is clear, my lord,
if
your lordship see the arbitration agreement for a moment, my lord, that is in page 67, my lord. I'm again referring to that, my lord. Lordship may come to page 67 of the petition, my lord, arbitration petition.
yes,
Clause 11.10, arbitration. In the event of any dispute arising under this agreement between the parties herein agree to surrender the dispute to arbitration by tribunal or to be constituted in accordance with the Arbitration and Conciliation Act 1996 or any statutory modification or reenactment thereof for the time being in courts. The tribunal shall consist of one arbitrator. The venue and seat of arbitration shall be at Guwahati. All arbitration proceedings shall be conducted in the English language. The arbitral award shall be substantiated in writing, and the tribunal shall also have the right to decide on the cost of arbitration proceedings. Any award made by the tribunal shall be final and binding on each of the parties that were parties to the dispute. Now, governing law and jurisdiction. The agreement shall be governed by the laws in India. The courts at Guwahati, Assam shall have exclusive jurisdiction over all the matters arising out of related to this agreement. So, my lord, there is even, my lord, there are judgments which says that, my lord, when the seat is decided, the jurisdiction will fall there, my lord. Now, the judgment, my lord, that 7 judgment, my lord, is the how the law has been changed, my lord. I will place it that, my lord, lordship. Just bear with me, my lord. The page para 90, my lord. And Companies Act, my learned referred to section 430. That is a civil court. It has been held that arbitration is a proceeding is not a civil court proceedings, my lord. I will place the judgment of our own High Court, my lord. Para 90, my lord. Arbitration Act is a self-contained code. Lordship got it.
1 minute. para 90.
90. The heading is the Arbitration Act is a self-contained code.
Yes.
In Girnar Trader versus State of Maharashtra, a constitutional bench of this court observed that a self-contained code is a complete legislation with regard to the purpose for which it is enacted. Such a self-contained code provides for a complete machinery to deal with the purpose thought to be achieved by the law, and its dependence on the other legislation is the either intent or absent or minimal. Then para 92, my lord. The Arbitration Act is a self-contained code inter alia with respect to matters dealing with appointment of arbitrators, commencement of arbitration, making of an award, and challenges to the arbitration award, as well as execution of such award. When a self-contained code is set out as a procedure, the applicability of general legal procedure would be impliedly excluded. Being self-contained exhaustive code on arbitration law, the Arbitration Act carries the imperative that what is permissible under the law ought to be performed only in the manner indicated and not otherwise. Accordingly, matter governed by the Arbitration Act, such as arbitration agreement, appointment of arbitrators, and competence of arbitration tribunal to rule on his jurisdiction have to be assessed in the matter specified under the law. The corollary is that it is not permissible to do what is not mentioned under the Arbitration Act. Therefore, the provisions of the other statutes, my lordship will mark it, other statutes cannot interfere with the working of the Arbitration Act unless specified otherwise. Then, my lord,
You come to para 95.
the law on arbitration agreement. Yes, madam. An arbitration agreement is the foundation. Before that, madam, para 94 is also important. May I read, my lord?
All right.
The Arbitration Act represents the principles of modern arbitration.
Why I want you to come to para 95
I read, madam.
is because of a query I want to ask you,
Oh, my lord. Then I'll read, madam.
so that you can come back to 94.
Yes, yes.
Sure.
Well, an arbitration agreement is the foundation of arbitration as it records the consent of the parties to submit their dispute to arbitration. In Bihar State of Mineral Development Corporation versus Incon Builders Private Limited, this court enlisted the essential elements of an arbitration agreement as follows. There must be a present or future difference in connection with some contemplated affair. There must be the inception of the parties to settle such disputes by the private
Intention.
Yes.
So intention, one of the primary requirements.
Yes.
Parties must agree.
Agree.
We will settle.
Yes.
Now the agreement which you are pointing out, he is questioning by saying that this is false.
No, he's not questioning that agreement is false. He's questioning that
He is
the
questioning the agreement.
no, lordship may see that is not his case. He is not questioning that agreement. He has not signed it. Suppose he signs an agreement.
What is the meaning of that prayer?
Which one, your lordship?
A.
Prayer A?
Prayer A. Your lordship, with reference to this agreement,
he wants to say that agreement is void. That's what he nikalo.
If the agreement is void, how do you enforce the arbitration clause?
That all agreements entered into by the respondents and or their agents nominees on or after 34/2001 to be declared as null and void. So on or after 34/2021 be declared as null and void.
It does not specifically refer to the agreement, but how do you say this agreement is excluded? On or after?
Yes, on or after. I'm saying that. But he's not denying that he has not signed the agreement. Of course, he may have a prayer that agreement should be declared, but he's not disputing that agreement is entered into by fraud. That is not his case. That is not his
what you're
case.
saying, aren't you? No. Do you accept this agreement of 30004, 2021?
your lordship, we have signed this agreement. We have signed, but this agreement stands terminated.
Why?
Terminated for non-compliance, and that is more than 1.5 years back. That is why we have made the prayer. And
you are oscillating between the prayers. You You focus on the on your submissions.
Right. This
What is your
this
submission?
agreement also, as we have already terminated, and there is a provision in 242 for setting aside the agreement. That is why we have made this prayer.
We are asking you again, this agreement of 20, with
30.
3004
Yes, Your Lordship.
contains your signature
Yes, Your Lordship.
vis-a-vis the prayer made in the company petition for
Yes, Your
setting
Lordship.
aside all agreements entered on or after
Hmm.
3004. What is your stand?
Because, Your Lordship, after entering into this agreement, there were several irregularity happened. That is why we are making to set aside this agreement as well, along with the other subsequent agreement entered by the respondent.
So you do not dispute that this agreement is in existence. You do not dispute that you had consciously signed this agreement.
No, I'm not disputing that I have not signed. I have signed.
You
but
have signed.
I have already.
So if you have signed, it contains an arbitration clause.
Right.
That arbitration clause is independent of this agreement.
No, Your Lordship. As there are other subsequent development
Whatever
happens
may be,
after the
whatever,
agreement,
that you go and
that is with reference to.
That you go and urge before the arbitrator.
Your Lordship, I'll just refer one paragraph of this judgment. That is paragraph 130 in Sultana Begum versus Premchand Jain. Para A, I'll refer. The court analyzes the relevant decision of the court and laid down the following principle pertaining to the harmonious construction of statute. A. It is the duty of the court to avoid a head-on clash between two sections of the act.
No. You have to read it in the context of the recent judgment.
That is the recent judgment. They have said
this Constitution bench judgment.
Yes, Your Lordship. I am referring from that judgment only. I'm referring one paragraph 160 of the court.
What is the ratio of the Constitution bench judgment? Ratio of the Constitution bench judgment. If I have understood, it's subject to correction from the bar. That once there is an arbitration agreement, irrespective in this case, it was whether arbitration agreement contained in a document under stamp or not stamp can be referred to, can be relied upon. Court concluded saying that this arbitration agreement is a separate agreement, it's a complete court, merely because the primary agreement in which it is contained was not admissible in evidence by virtue of some technical defect. Cannot say that there is no arbitration.
Your Lordship, court has also made an observation in bold that harmonious construction of three statute under consideration the effect of the competence doctrine.
Yes.
Yes.
So the competence doctrine is that once the arbitration agreement is there, it is the arbitrator who is competent to decide on everything, including the jurisdiction, including the arbitrability of the dispute. Is what competence.
Your Lordship, when there is a special law, how this can be referred?
Where is the special law?
Companies Act, Your Lordship.
Companies Act, you are praying for mismanagement. You do that.
Not only mismanagement, Your Lordship. I have referred to section 59 as well. 59, what it says? Rectification in register of member of shareholder.
Whatever it may be. These
And
are open to you.
242 is having inherent power.
The only question is whether there is an arbitration clause under this agreement and whether any disputes arise in this agreement. If so, you go for arbitration.
Arbitrator does not have the power, Your Lordship, to send this document for forensic.
Arbitrator has all the powers for any orders or pass any orders they want. It can set out its own procedure. You can make your application to the arbitrator, call for forensic audit. You want.
Not only forensic audit, Your Lordship. As this matter, there is a criminal case is also going on for forgery.
How will the NCLT decide?
NCLT, I have made an application under 447. They can have a prima facie finding and can refer it to
What
the
happens
special
to
court.
the criminal matters which are pending, also filed by you in competent court of criminal jurisdiction? By your own theory of harmonious construction, what happens to those matters? They're filed by you. Do you want to say that because it is the NCLT, it can decide all matters relating to the company, notwithstanding applications being filed for the appropriate order.
Your Lordship, with reference to 241, 242, there are specific provisions.
Yes, there are, but
Yes.
you have already approached those forums.
And
this argument would have been available to you if you had not pressed further into those applications which are pending before the Court of Criminal Justice.
Criminal case, Your Lordship, having the independent jurisdiction, that is the only reason
To
the
decide
client
what? Decide what? If the NCLT can already decide.
NCLT can have the prima facie
Can
finding.
there be can you approach dual forums at the same time?
No.
You are doing that. You're doing that. On one hand, you are saying that before the criminal court it is pending. On the other hand, you say no, it is the NCLT, right?
Not decide, Your Lordship, can have the prima facie finding. That is with reference to separate other documents.
Prima facie finding will again have an effect on the criminal matters.
Your Lordship, what has happened? I have filed the criminal case before. Thereafter, they have filed a reply disclosing certain documents. That I have challenged in NCLT because I can't go to the criminal court again and again when I have already filed a complaint. That is with reference to separate documents, subsequent event. That they have forged the share certificate and the signatures, everything. They have disclosed in their reply these documents.
Your prima facie argument that because the NCLT has already assumed jurisdiction, arbitrator cannot.
Not only that, Your Lordship. Number two, when the ownership under challenge, how can they represent themselves as the owner of the petitioner number 1 company? How can they represent that company?
We don't know. It is for the arbitrator to decide.
That is the NCLT to decide, Your Lordship, that who is the owner at the end of. That is the NCLT to decide. That is the petition over there.
It is for the arbitrator to decide. NCLT no order has been passed as on date.
Your Lordship, completion of pleading orders are there, and thereafter the matter will be heard at the earliest, because Your Lordship very well aware there is a shortage of members.
No application has been made that this agreement be kept under suspension.
Your Lordship, if it is there in the main petition,
unless you are clear about what you want and the process, it appears prima facie that you don't want to agree to the conditions.
I'm not agreeing, Your Lordship. That moment of time we have signed, but thereafter, that is why we have approached to the NCLT. That we are challenging this agreement.
You may have, but then before the NCLT, you have not been able to produce any orders to say that this reference to arbitration or the execution of this agreement be kept under suspension till the matter is decided by the NCLT. No order is there. There is a view of a coordinate bench to say that the matter needs to be reviewed and recalled because this application for arbitration was filed on an earlier date prior to the one filed before the NCLT.
Your Lordship, they have also made submission. A service has been made to the petition of some different petition, means like one more petition that was having several defects. After receiving the copy, that is the counterblast, they came up with an arbitration petition.
Whatever it may be, but arbitration petition they are entitled to file in view of the non-appointment of the arbitrator in terms of the arbitration clause. You are not denying the existence of this clause of the agreement. Yes.
Lordship, I'll cite certain judgments. I'll come up with certain judgments.
We'll give you some time to get out of the mud that you got yourself stuck into. So let us have it. When? This is a good time to come to Guwahati weather-wise.
Your
Come back next
yesterday, actually, I requested my learned friend as well that I won't be able to come because yesterday my daughter has taken the vaccination of 6 months. So, but they refuse that. No, I don't give. I will not take allow the consent. So that is why I'm here today.
But you are here.
Yes.
We had
And
indicated.
I'll show my
we-
wife
we-
WhatsApp as well what she's texting me.
No. We had indicated earlier that we don't want to pull you out of your
Yes, that's what the
association with your daughter. We have VC facilities. You can argue from Calcutta if you want, or any place else, if you want.
No, I love to come over here. Basically, otherwise.
That is also possible because Guwahati is otherwise a good place. Yes. We want to take it up next week and finish it.
After 4th, if any day possible.
After 4th week, it's not possible.
Because next week I am appointed by as a scrutinizer in one of the matter by the court. Next Friday.
Can't help it.
After 4th, Your Lordship.
You come back on 25th.
Your Lordship, I am having my matter on 25th, Your Lordship. Lot of matter scheduled on 25th. Your Lordship.
Then on 26th.
Yes, Your Lordship. Part-head matter is there. 26th.
This is also part of.
Prefixed part-head matter, Your Lordship.
All right, 27, no further.
Your 27th, as I said, Your Lordship, I am acting as a scrutinizer in one of the court appointed.
Oh, then come on Monday.
Lordship, can it be after 4th, Your Lordship?
After 4th, you go to end of October. Because we are closing. Third, learn it down. Party. Matter was heard and something. Further hearing to continue. It's taken on
26
of
this month, my lord.
your friend is not willing to come. You are scaring him.
Then it will go after vacation, my lord. That is the problem.
30th.
1, 2, 3,
30th.
30th. 30th Monday, my lord.
30th.
30th September.
Last week you are not.
24th.
Then 30th of October. Yes.
24th.
30th
I
of
need to lost it because I'm
30th of October.
Application. 24th.
Yes.
24th.
24th, we are available, but you convince your friend to come 24th.
24th. Yes, my lord.
He is a busy father, unlike you. So he's time. So
My lord, 30th, my lord.
30th of October. Yes.
Obliged, Your Lordship.
But you come with whatever ammunition you want.
I'll come with
Don't
it.
tell me that you have got
No, no.
judgments, but you did not bring them.
No,
They're
Your Lordship.
available here. All right?
I shall, Your Lordship.
Yes.
Much welcome.
Yes. Next item.
Your Lordship, as per the instruction of the court, we have inquired with the company BPCL. If you can transfer it, they have strictly declined our request. So the matter may be taken to arbitration.
We don't get you. Sorry.
Your Lordship, we have inquired with BPCL, from whom we have taken the domestic commercial license for distribution of our cylinder gases.
Where is the agreement?
Lordship will find the agreement in page number 17 and the arbitration clause at page 22.
17.
17.
1 second. Yes.
Page 22 is the arbitration clause.
22.
22.
22. Point number 20.
So who represents Jitumani Medhi
Lordship, I'm representing Jitumani.
and Bhakanta Kumar Gogoi.
I'm for the petitioner.
Where is your application notice asking them to appoint?
Lordship, page number 28, annexure 4 or 5. Lordship. Page 28, annexure 5.
You're not you filed your objection.
Yes, Your Lordship, I filed, and in pursuance to that,
Mhm.
kindly refer to page number 63, the agreement, the initial license agreement, page number 63, clause 21. The distributor shall not sell, assign, mortgage, or any part otherwise transfer
Wait,
his
wait, wait.
interest.
Page number
63.
63. Yes.
Lordship, point number 21. The distributor, that is me,
Yes.
shall not sell, assign, mortgage, or part with or otherwise transfer his interest in the distributorship or the right interest benefit conferred on him by this agreement to any other person. Sir, we, after entering into that agreement, Your Lordship, we have came to know about that fact. But Your Lordship, when we inquired again with the company BPCL, can we transfer the license to any other person? They have strictly declined it. So, Your Lordship, the dispute.
What do you say?
Lordship, there is a dispute in this case. Even my learned friend agrees, and
There is a dispute,
Yes.
but they were appointed the distributor.
Yes.
So you entered into an agreement to transfer. That is not permissible under the parent act, under the parent agreement.
Lordship, he is the license holder of the gas agency. So initially, he took that license from the company, and he has given me to run the gas agency.
But he's not authorized to do it.
Lordship, he has already signed an notarized agreement, and I have invested.
You may have done it, but you did not check up this agreement first.
Lordship, he is the license holder. He intended, he in fact approached me to run the proposed gas agency due to some financial constraint he was facing. So I initially invested it in, and after that we notarized an agreement also. Then I was running the gas agency after
Now-
investing a lot of money, and verbally
What is your claim now?
my claim is to because I had invested a lot of money, and after that forcefully he has taken over the possession of the agency from me. So I had sent notices to settle the accounts between us, but there was no response from his side. So I had sent that notice under Section 11 of the Arbitration Act for mutually appointing an arbitrator, but there was no response from that. And we have approached this court for appointment of an arbitrator to settle the dispute which has emerged between us.
Your Lordship, they have filed after they have filed the application, and then we have studied the matter. We were contemplating to file the civil suit for cancellation, but it cannot be done now since an arbitration proceeding is pending appointment. But the point here is the dispute will arise only for the money transaction, maybe, Your Lordship, but the transfer of those distributorship, the BPCL has not agreed to us. We've approached them also. They will not allow it. That's why they ought to have made party.
Lordship, my agreement is with the defendant side. I don't have any business with BCPL.
BPCL, it's not, but BPCL will be providing the gas.
The agreement also is between us. The company is not the party in the agreement.
Okay, heard, learned counsel for the party. This application is filed by the petitioner. It's going to. Of the arbitration is totally 1996. Praying for a direction to appoint an arbitrator in terms of the agreement executed. Where is that agreement again?
Agreement page number 17. Annex Z2.
By and between the petitioner and the respondent, dated 4th of June 2018. You are not denying this agreement.
No, we are not denying. In pursuant to this, we have taken some advance.
Learned counsel for the petitioner submit that the respondent was the distributor of Bharat Gas for supply of LPG.
LPG cylinder.
LPG cylinders. So, because of his inability to effectively run the distributorship, the respondent approached the petitioner to ensure that the distributorship is run efficiently, and accordingly offered a proposal to the petitioner to operate / run and function the day-to-day business of the LPG distributorship at Hiranpara in Guwahati by paying monetary consideration to him. So, the petitioner agreed to the proposal, and the instant agreement dated so and so 4th of June 2018 was executed by and between. So, in the said agreement, at clause 22, is provided that any disputes, controversy, claim or breach arising out of or in relation to this agreement shall be referred to arbitration as per provisions of the Arbitration Act. So, the place of arbitration shall be Guwahati, and the language of the arbitration shall be English. So, pursuant to the execution of the agreement, the petitioner undertook the day-to-day execution of the business, day-to-day operation of the business of distributorship of the respondent. So, subsequently, disputes arose between the parties, and it is alleged that the respondent had taken over the distributorship in contravention of the agreement executed by dispossessing the petitioner and declining to complete the monetary consideration which was earlier agreed upon by virtue of the agreement dated so. So, being aggrieved, the petitioner issued a notice under the provisions of Arbitration and Conciliation Act. ID notice dated 10th of March 2023, calling upon the where is the notice calling upon him to appoint an arbitrator?
Page 28.
had earlier issued a notice dated 10th of March 2023 on the respondent demanding for return of the amount invested to the tune of 1, 31, 18, 605.46 within 15 days. So the since no response, any response was issued? No response was issued by the respondent. Petitioner issued a notice under Section 11 of the Arbitration and Conciliation Act, dated 3/5/2023, calling upon the respondent to appoint an arbitrator within a period of 30 days from the date of receipt of the notice. So, the notice was sent by registered post on
Same date.
the same date. So, as per the tracking report, the letter was delivered on 6/5/2023. Was shown to be received and delivered and received by the respondent on 6/5/2023. So, in spite of the notice being issued, the petitioner not having appointed the sole respondent, the present petition is filed. Where Learned counsel for the respondent, on the other hand, has filed an objection opposing the prayers of the petition. Submits that by virtue of the agreement executed between the respondent and the BPCL, as per clause 21, the distributor appointed shall not sell, assign, mortgage or part with, or otherwise transfer his interest in the distributorship or the right, interest or benefit conferred on him by the agreement executed by and between the respondent and the BPCL authority. He further submits that BPCL authorities were necessary party and were required to be arrayed as party respondent. The petitioner filed you filed any reply to the objections? Did you file any reply?
No.
Learned counsels for the parties have been heard, speaking to on record. The root. It is seen that an agreement dated 4th of June. What was the date of the agreement? Sorry, 4th of June 2018. What is this agreement of 10th of August?
Usually we have entered the agreement.
Lordship, after he approached me to run the business, so temporarily we had entered into an agreement to run the business. After that, subsequently another agreement was done where the arbitration clause was there. On both the agreements, there's an arbitration clause.
As per the agreement dated 4th of June 2016, the parties executed the said agreement and entered into and agreed to the arrangement that the petitioner shall operate, run, function day-to-day business of the LPG distributorship at Thirenpara, Guwahati, under the name and style Protima Bharat Gas Agency, which belong to the respondent. Stop. In terms of the agreement, the following was agreed upon. Page number 18 and 19. Sheet of agreement, the total amount is written. Stop. Para. The agreement also contains an arbitration clause, being clause number 22, which reads as under page number 22. Expect. Although an objection has been filed by the respondent, however, the existence of the agreement executed by and between the petitioner and the respondent by the agreement dated 4th of June 2018 has not been disputed or denied by the respondent. Stop. It is also not denied that it is also not disputed by the respondent that the notice required under the statute under section 11 of the statute was served on the respondent and he failed to appear and he failed to appoint the sole arbitrator as and he failed to appoint the sole arbitrator he failed to agree for appointment of a sole arbitrator as per clause 22 of the agreement. So, even during the course of the hearing, the counsel for the respondent does not dispute the contentions raised by the petitioner, nor does he dispute the fact that no attempt was made to appoint the arbitrator in terms of clause 22 of the agreement. Under such circumstances, this court, under exercise of section 11(6) of the Arbitration and Conciliation Act, he is now required to appoint an arbitrator. Stop. The sole arbitrator in terms of the agreement dated. Under such circumstances, do you have any suggestion for arbitrator?
No.
Appoint Justice Dinesh Maheshwari, former judge of the Supreme Court, to act as an arbitrator in terms of the disputes arising between the petitioners and the respondent in respect of the agreement dated 4th of June 2018 and 20. So, subject to the disclosure being furnished by Justice Rancho in terms of section 12 the section 12. Sri so-and-so is appointed as an arbitrator to arbitrate on the disputes and resolve the disputes between the parties to the agreement dated 12. The arbitration petition accordingly stands loved in terms of the above. The parties will place a copy of this order before the learned arbitrator appointed by the
Obliged.
Major Lordship.
Yes.
This is an application for appointment of arbitrator, my lord. And the petitioner earlier filed a writ petition wherein, my lord, the honorable court has passed directed to approve the department for appointment of arbitrator. I would like to place the order of this honorable court, my lord, page 52. And 11 paragraph is at page 54. Page 54, last paragraph I am reading, my lord. That in view of the said provision of the GCC, without expressing any opinion on the merit of the dispute, this writ petition is disposed of by leaving it open for the parties to get the dispute redressed through a process of arbitration as provided by the GCC. Since the contractor, the petitioner is the aggrieved party, being aggrieved by the cancellation of contract, the petitioner contractor may also make necessary application for not encashing the bank guarantee as well as the security deposit for the time required for appointment and initiation arbitration proceeding. It is needless to state that once the arbitration proceeding is initiated, proper application can also be made before the arbitrator for such relief as provided in the Arbitration and Conciliation 1996. Thereafter, my lord, next page is page 55. They have approached. The order is of, my lord, 27 May 22, long back. And they have encased the securities also, in spite of application. So 6/6/22, my lord, he has approached that with due respect, I would like to draw your kind attention that the Guwahati Honorable High Court has passed the order so directing the petitioner approach the authority for appointment of arbitrator as well as for getting appropriate relief regarding termination of contract. I hereby submitting the certificate copy of the order that so-and-so passed in so-and-so in your information compliance. I am eagerly waiting for compliance of the order of the Honorable Court by appointing arbitrator as early as possible. Thereafter, my lord, another letter is there. 31st October 22, and he has repeatedly visiting the office also personally. That with reference
So what
to your
reply? What reply has come?
reply, my lord, that is in page 59. Recent reply. He was approaching again and personally visiting the office also. But in spite of that, my lord, they have not passed any order. This letter is of, my lord, only 2/2/24. That in reference to your above letter, I would like to bring to your kind attention that the total amount of claims, rupees 14 crores, so and so a month, which is the value of so a month. It may also be noted that the, as per contract agreement clause for so and so, the provision of clauses 60 and 64 to the general contract will be applicable only for settlement of claims or disputes between the parties for values less than or equal to 20% of the value of the contract, and when claims of dispute are of value more than 20% of the above the contract provision of clause and other relevant clause of general condition of contract will not be applicable, and arbitration will not be a remedy for settlement of such dispute. It has come, the bar has come for pecuniary jurisdiction. His claim is that, my lord, at page 58, claim is more. They although discussed, they could not apply. Page 58, that in reference to your above letter, I am submitting my detailed arbitration claim amounting to rupees 19 crore, 84 lakh so and so. I am enclosing the details for formation of arbitral tribunal as per GCC clause 64(1)(2). You are requested to kindly do the needful by initiating an appointment of arbitrators. I will be highly obliged for your early action. So this letter is of my lord 1st of December 2023. So after 1.5 years, then gone, which is of application. And again, my lord, last letter is 21st of February 24. As yes, Honorable Court has also earlier passed the order, my lord, for appointment of arbitrator. So, my lord, your lordship may kindly direct to refer the case to the arbitrator so
Yes,
that they can
Mr. Gogoi.
dispute the things.
Lordships, we have filed affidavit as per Mayor's direction, Lordship.
Hmm.
The claim is admittedly, Lordship, more than Lordship 20%. So, Lordship, it is not arbitrable as per the clause of the agreement, Lordship. And as per his claim, page 58, Lordship, it says that, Lordship, arbitration claim is amounting
There is
to.
already two orders,
Lordship, our High Court order is there. Lordship.
two orders
Oh.
that the issue is to be decided by the arbitrator.
No, Lord. No.
Yes.
Our High Court decision is there, Lordship. Our High Court judgment is there.
Yes, that's
I have, I have given, Lordship, one judgment that is there, another is also there, Lordship.
Supreme Court decision also there, my lord, only in the High Court. Of the same judge, I'm also having judgment. Okay.
There is one judgment by this bench also.
Regarding that issue already decided by the.
We have seen it.
Three judgment is there.
As per the- As per the act, my lord,
As per the act, that is there, Lordship. Otherwise, Lordship, as per the GCC, we have to go by the GCC, Lordship. And that
So-
was also decided by Honorable Delhi High Court also, Lord.
I'm also pressing two judgments, my lord. One is our High Court. By the same judge, my lord, earlier the dismissal, my lord, dismissal by Honorable Justice.
That
Michael,
judgment,
my-
Lordship, nothing is
No,
there.
there is a judgment by this court in respect of the railway contract only by
Rail-
Justice Singh.
Railway contract, Lordship, as per the GCC, Lordship, that claim is less than 20%, then
No, no,
Lordship,
there-
Lordship,
No, that's what I'm saying.
Yeah.
So there is another judgment of the coordinate bench.
Lordship. Like, that is there. If
As well as I'm bound by my judgment.
If 20, less than 20%, then Lordship, it is arbitrable, Lordship. But
The view of the court
Lordship,
as well as the view
Yeah.
taken by this court
Lordship,
is that following the earlier judgment
Lordship.
is that the question of whether it is arbitrable or not arbitrable, because there is some confusion with the clauses earlier.
That
What is
Lordship, that
what is
is
the
Lordship.
claim amount?
Here claim amount is Lordship more than 20%. It is more than 50%, Lordship. So it was decided by our High Court regarding that claim amount,
It
Lordship.
shall not, kindly read the arbitration clauses.
Married, or-
Yes, yes.
Clause, Lordship, here clause 47, Lordship. Clause 47.
What, 64?
64 is the arbitration, Lordship. Clause arbitration,
Arbitration.
Lordship. It is read with, Lordship, clause 47 of the
Page 26.
agreement, Lordship. But agreement is not annexed here, Lordship.
page 26, my lord. And determined by the judge.
It is in respect of demand for arbitration. But Lordship, the special contract which was Lordship executed between the parties, there is a clause that is clause 47, where it says that,
That is the
Lordship,
maintenance and.
where it says that, Lordship, or the applying the, Lordship, clause 63 and 64, Lordship, it should be as part of composition of the clause 47 of the contract agreement, Lordship. That contract agreement was not annexed here, Lordship. And we have categorically stated our orders also, Lordship, and the letters also, as well as our affidavit also, Lordship.
No, but where is that agreement?
Agreement part, Lordship, it should be by the petitioners, they have to place it.
You produce the copy of the agreement.
No, I don't have any agreement, my lord.
Huh?
You have to produce it, you have to.
They keep it actually.
No,
They
no.
don't
No,
keep it.
no,
How can
how
they
can
keep
I
it?
take?
You have signed an agreement.
Lordship,
You have got this extracts.
Lordship.
Where have you got these extracts?
But this is here, part of the GCC, Lordship.
Where
Part of the
have you got the GCC from?
Yes,
Lordship.
my lord. But agreement is not.
Agreement, without agreement,
No, but
how he can.
GCC is a
execute?
part.
They don't give, my lord.
No,
Like the
GCC.
insurance company, like the
It is a
insurance
totally
company,
100% false
they keep
statement,
it, my
Lordship.
lord.
Without the agreement, Lordship, how he can execute the work, Lordship?
This GCC is a part of the
Agreement,
agreement.
yes.
So how is it possible that you have entered into a contract without retaining a
That
copy
is
for
not
yourself?
that 47 clause, that is not there. Can, your lordship, may
It
kindly
is,
ask
it
him
is
to
the,
read
it is their agreement, Lordship.
47.
It is their agreement,
47.
Lordship. It is their agreement, Lordship.
47.
Why don't you produce the copy of the agreement?
I have to ask for Because the person is not from here, my lord.
Wherever he is from, he must be having a,
He's from Arunachal.
wherever he is.
Yes, my lord. But earlier did not
Yes,
say I also
yes,
did not
yes.
tell the relevant.
According to them,
Relevant-
47 is the clause for contract.
Yes, my lord.
So the clause for contract has,
47 extract is there, my lord, 47, but this 47 is not the part of this contract. This is the contract, GCC contract. 47 is not applicable because it is regarding maintenance and measurement.
No, Lordship.
Measurement.
No, no.
So have
No,
we have
Lord.
that 47
No,
block?
have you extracted 47 here?
47. Yes, my lord, 47. This is the clause 47. This is maintenance of works.
No, no, is it a part of the pleadings?
No.
Have you extracted the part, the clause 47 here?
47. I have.
Then please extract it.
Since a judgment is there from the honorable court.
But we must know whether you fit into that clause. You are
47.
asking for an arbitration.
Yes, my lord. That is not
Allow
what I
us
have
to-
read. That's why I did not enclose, my lord.
Why?
47 is maintenance of work. It says maintenance of work.
Have you seen their objections? They
Yes.
filed an objection.
Yes,
So they
I've
say
seen
it is
that
not
one.
maintainable in view of
because my lord,
46.
if any objection is there, that will be dealt by the arbitrator, my lord.
First, you show us the provision. Where have you stated in your objection that not maintainable?
Paragraph 24 and 27, Lordship.
24.
24 is the internal page 74, Lordship.
Twenty-four talks about 63 and 64.
63 and 64, Lordship. Otherwise, Lordship, it is as per our that rejection letter, it is 64 and 64 is
47.
as per the clause 47, Lordship.
But where have you stated all that?
Lordship.
What is this?
This is the extract of 47, my lord.
Oh, no, we can't read it. Sorry.
Not readable also. That is not.
Where have you stated, denied that it is not arbitrable?
Lordship, 46, 24, we have already said, we have stated, Lordship.
There are 24.
24, Lordship. If Lordship, I can read it, Lordship.
Read it.
The statement made in paragraph 20 of the arbitration petition, the ensuing deponent begs to state that as per the provision of GCC clause 63-64, the GCC will be applicable only for the settlement of claims dispute between the parties for values less than or equal to 20% of the contract value. And when the claims of disputes are a value more than 20% of the value of the contract, provision of the clause 63 and 64 and other relevant clauses of the GCC will not be applicable and arbitration will not be a remedy of settlement. In this case, the contractor claim is lordship more than 51.59%. And in this regard, railway issued a letter to the contractor on so and so and review the claim less than or equal to the 20% of the value of the contract as per the contract agreement to settlement the dispute, but contractor not reviewed the claim lordship. Now, as per the clause 47 lordship, there is a provision is there lordship, it should be less than 20% lordship. Then 27 also we have reiterated the same part lordship. And even we have also lordship, we requested him to review the claim lordship. That part was also not done lordship.
And
Otherwise, lordship, not only 3 judgment lordship, another 2 judgment is there before our high court lordship. It says that the claim should be less than 20%. Honorable Division Bench of the Delhi High Court also decided that particular issue lordship. And I have the another 5 high court judgment is there lordship, regarding that GCC clause lordship.
hundreds of decisions.
Otherwise, like, as per as GCC, that is lordship's power lordship. But the claim should be less than 20%, equal 20% or less than 20%.
No, who decides?
Lordship, that part as per the claim itself, lordship. Claim itself, lordship may kindly peruse the claim.
No. Who
Claim
is to
value.
decide whether this is arbitrable or not arbitrable?
If GCC says that If this is says that it is more than 20%, then immediately he is not, it is not arbitrable. My lord, for a moment, kindly close
No,
case
in
15.
order to decide the
Lordship.
claims of 20% or less than 20%, one has to go into the claims.
So, Lordship, his claim is his claim. What is the amount of the claim, Lordship? Amount of the claim is, Lordship, in page 58. It is, Lordship, 19 crores, Lordship, 84 lakhs 87,632. And the work value is, Lordship, 28 crores 61 lakhs 40,598. Admittedly, it is more than 50%, Lordship.
Because they have not paid.
Admittedly, more than 50%. It is not a dispute that, Lordship, the work value is, Lordship.
You kindly read this clause number 63, page 26.
63, 64, Lordship, we have to read conjointly with, Lordship, 47 of the CA.
No, first you read
No,
63.
If 63, Lordship,
Yes.
Page 26.
matters are finally determined by the railway, Lordship. The Indian Railways arbitration rules. All the disputes or differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion of whether before or after the determination of the contract, shall be referred by the contractor to the GM of the GM, and the GM shall within 120 days after receipt of the contractor representation make and notify decision on all the matters referred to by the contractor in writing, provided that matters for which provisions has been made in clause 8, 18, 22, 5, 39, 43, 2, 45, A, 55, 55A, and 57, 57A, 61, 1, 61, 2, and 61, 1, and Roman 3B of the general condition of contract or any clause of special condition of the contract shall be deemed to accepted matters not arbitrable. That is, Lordship, so we have to read the, Lordship, CA, special condition of contract. That is CA, it is specifically mentioned that, Lordship, it should be less than equal to 20%, not more than 20%, Lordship. So we have to conjointly read with the CA, Lordship. Then, Lordship, demand for arbitration, 64.1. In the event of, so, Lordship, first we have to fulfill the, Lordship, 63, Lordship.
Where is 63? Sorry.
47, it is
47.
not there, Lordship. It is not there. It is not there.
Please get 47, 48 of the contract.
Take it. And his
Well,
petitioner will also
then
produce,
dashing,
Lordship.
but-
I can also try produce the same.
Produce.
Lordship.
Since arbitration clause is there, if the amount is beyond, because below 20%, only their arbitrator will decide.
20% of what?
20% of the work value.
But your amount prima facie appears to be more than 20%.
And yes, because the contract was for 28 crores. And my lord, no payment was made
therefore-
against that work done.
No. So therefore, it is not
Yes, my lord. It
referable.
cannot be. It cannot be. Below 20% is not my claim. So their arbitrator cannot decide it.
Where is that clause? That's what we are trying to find out. You are not placing that clause.
This is the, he has read, my lord, that
You get
last
the
is,
agreement.
my lord, deemed to accepted matters not arbitrary. And decisions of the
Madam,
railway
please,
authority, last
please make an attempt to give us the relevant clause.
47, 48.
Yes. Heard learned counsel for the parties. Matter deferred at the request of learned counsel for the petitioner to produce the copy of the arbitration agreement.
But contract agreement, Lordship, CA.
Contract agreement
Contract.
pertaining to the contract
But-
in which the disputes have been claimed to have arisen between the parties. Matter be listed. The month of November.
Oh, look, since 22, he is waiting, my lord.
So you
So,
when
my
can you
lord, next
produce?
Friday, next
Huh?
Friday,
Next Friday.
Yes,
Right,
Friday.
27th of
Lordship.
September. Mr. K. Gogoi, learned he appears for the railway.
Lordship. All right.
Obliged.
Yes.
My lord, my learned friend is supposed to produce update case ID.
They keep the judgment or I should take away?
You give it back on next. Yes.
My lord, in this matter, my lord, on earlier occasion, my lord, the up-to-date CD and along with the report of service was called for, my lord. My lord, I have been informed by the police station that it was served, but the report yet not received, my lord. Along with the CD, maybe my lord may grant any date in the next week, my lord. But they have said that through outpost they have served it, but the report that is not received.
But 438 is barred under, sorry, this petition is barred under 438.
But it is barred, my lord, if there is
There
something.
is,
My lord, on mere allegation is not barred.
this is what he says, accusation. Read 438-4.
Accusation, but the case diary, if case diary reveals, my lord, that some offense has been committed, my lord, then it is here FIR, my lord. If the case diary reveals materials, my lord, then my lord, it will be cancelled.
Mr. APP, take this, take this. Take
my
Kerala, Kerala. Okay. Wait, my lord. Here, my lord, if the victim is below 16.
See 430, 438-4. Then
376.
you not even raise that objection. It should be your primary objection.
Yes.
Show it to your counterpart.
My lord, on accusation of having committed an offense.
Huh?
My lord, here on accusation of having committed an offense under
Accusation.
Accusation.
What is the meaning of accusation?
that, my lord, but in 376(3), the victim should under 16. Yes.
Show me your any judgment that if you have.
My lord, 376 definition of section 376(3). 376(3) it says, my lord, when rape is committed to a girl below the age of 16. My lord, so is that my friend can show the what is the age? My lord, here is mentioned 15 years, but
Minor girl, 15 years. Then
her birth certificate is required.
that is a matter of trial.
My lord, well, let it be. My lord, when 376(3) come, my lord.
Under 16?
Under 16, my lord. But without case, I have also not birth certificate.
Is there any birth certificate?
Birth certificate, my lord, not annexed, but earlier when rejected, my lord, it is earlier rejected, my lord. Earlier rejected on, my lord, that is 2012-2023, my lord. Where it is jointly, it was filed, my lord, and the present petitioner was the petitioner number 1.
Case 21, paragraph 6, my lord. In fact, there was a love affair, my lord.
when something is specifically barred,
Yes,
you have
it's
to give
barred.
us material. What else?
My lord,
Your explanation that you're trying to provide in respect of this section will not apply unless.
my lord, in that case, my lord, let be posted on Monday or Tuesday. I will try to bring something.
When can you get the updated CD?
My lord, by Wednesday, my lord.
Wednesday. All right, 27th. then.
My lord.
My lord.
List on 27th. Meanwhile, the learned APP
My lord.
seeks some time to call for the updated CD.
My lord.
List accordingly on 27th
Deeply okay.
September. Huh? Only.
Informant, my lord.
You know, there is some mismatch.
Yes, sir, I have to.
Your file is not before us. The file name of the party shown in the cause list is not the file that we have.
This case has been was fixed on 23rd.
Somehow it has come.
Okay.
Secondly, today
The item shown to be listed as item number 25. The court records of AB 1933 of 2023 has been listed, has been placed before the court, while the cause list reflects the item 25 as AB 1933 of 2024. Registry to make necessary corrections and list AB 1933 of 2024 on.
It is fixed on 23.
Oh,
Yes, on Monday.
then you write learned counsel, Mr. Chaudhary, appearing for the petitioner, submits that the petition AB 1933-2024, which is shown as item 25 in the daily cause list today, as per the last order, is already fixed on
23.
23/09/2023. Accordingly, let AB 1933
Yes.
of 2024 be listed on 2023.
My lord, CD receipt in this matter. CD receipt, my lord. To retain
If the CD in connection to the said matter is received, the learned APP will retain the said CD. Received in AB 1933. Which matter?
My lord, 1933/2024. That
24.
is the causeless matter, my lord, which is listed in the causeless matter.
You have received CD in which matter?
My lord, AB 1933/2024.
This is our
24.
24.
Yes, all right, 24. AB 1933 of 2023 to be listed after vacation on a date to be fixed by the registry.
It is already fixed. On 23.
No, this is 23.
Yes.
Yes.
So
The numbers are the same, but the
Yes,
year is different.